the first to know Nsem-Pii TV.
Nyankopon ya domu a ochina all roads will lead to the financial, criminal and economic division of the Accra High Court. Bra Justice Efia Sewa Asari Butchi Eddie ruling about to in respect to motions mienu ya the first accused the case Latoforsen and the third accused Richard Jakpa a file ye ewo court seeking the court to dismiss all criminal charges pressed against them. Ya omo evidence omo gina so enti omo hwehwe se court ebe dismiss all these criminal charges. A leaked tape ya ekura conversations between the Attorney General Godfrey Yeboadame and the third accused Richard Jakpa and bakonso between the Attorney General Godfrey Yeboadame, a Supreme Court Justice Yoni Kulendi, and the third accused Bill Richard Jakpa were the residents of the Supreme Court Justice. Now a learned lawyer Oyegani Oyejuma ewo the ECOWAS court where did so many high profile cases. Your friend counsel Daniel crime. Wadinchiremwaba na a massive blow to the NDC any lawyers, lawyer Eduzita Makulu, lawyer Dr. Bassett Bamba, and a lawyer Thaddeus Sorry. The learned Daniel Crime Counsel, Chirimwa, the Attorney General Godfrey Yeboadame, Emremuno, sa audio no, mfonso bi anim. Osip sa plea bargaining no ye de abeka yemra ho. Ade so obi a on kenkan. And say obi a wa kenkan na emu no because of political mischief nti. Obu na ni eguso. But everything about the plea bargaining emra ni ababa beka ye criminal procedural activities hono. Obi wa kenkan obi anim say the tape itself, there is nothing wrong with it when it comes to law. What your commentary how do anypa be ma? The commentary ayema nyina eye based on ethics, sentiments, and ye amamre culture, but it is not based on law. Then chiremo de mai or see some members of the public have called for the head of the Attorney General, the Honorable Godfrey Dame, following his alleged leaked phone conversation with Richard Jakpa, the third accused, in the ongoing ambulance trial. The case involves the minority leader, Dr. Casey Latoforsen, Mr. Richard Jakpa, and one other. The Attorney General has been publicly condemned for allegedly seeking to induce one of the accused persons, Richard Jakpa, to testify against the first accused, Dr. Casey Latoforsen. While some members of the public have charged the Attorney General with professional misconduct, others have called for his immediate removal from office. Now, the question is, did the Attorney General go wrong professionally or in law by seeking the cooperation of the third accused against Dr. Casey Latoforsen? This article is my contribution to the debate. The learned Daniel Crenshaw and which room say, in fact, the baby can Nsem-Pii the Attorney General, a di on cano cre the three more day or ye evil or ye say Nina is as a result of. Then so Nina Muno or no counsel Daniel crying Shamren Mua said the independent Susian the pipe Genesia and yes, sir, and Amranoka, enti and our chess article ya or the air better in some no other churches. Or say the Attorney General's alleged secret engagement with the third accused seems to have shocked most Ghanaians because our traditional understanding of criminal trial is that it is always an adversarial contest between the Republic, represented by the Attorney General on one side and the accused on the other side, in a typical adversarial criminal trial. The Attorney General and the accused may be said to be opponents who are not supposed to engage in conversations and deals, secret or open. However, with the introduction of plea bargaining into our law, criminal trial has greatly shared its adversarialism. The ordinary say, first, traditional criminal trial, no, akwa say, Attorney General jinafa, and nipa no abo no kwadu no jinafa, and aye twema mentwe, enti no enkomodi die bi enkoso won ntem because we bo we kwadu, we so kan sem e de yi ne ho an. But plea bargaining ba mu no, sa de no ane da between the prosecutor, that is the Attorney General, and the accused no. Eni was abi o. The Attorney General today and an accused person may eat together from the same bowl, sit together on the same couch, board one vehicle, or chat with each other, all in an attempt to strike a plea deal as according to the law. There is nothing wrong with the Attorney General having a private conversation with one accused person and seeking his cooperation to prosecute another accused person. Now, one of plea bargaining's greatest advantages is that in syndicated crimes, like the case before us, one accused may enter into an agreement to plead guilty in exchange for a reward, so that he will assist the Attorney General to prosecute other accused persons. This often happens when the Attorney General is of the view that more concrete evidence may be obtained from one accused to bolster or augment the case of the prosecution against the ringleader or kingpin in a group crime. Enti the learned Daniel Crane Chirimuha, plea bargaining in a buy, and Makwan say, Attorney General, any an accused person, able to me at table what to say didi, able to me at couch bakumo dinkomo. Betimi atraka baakomu atumpasa. Esa ne say. Plea bargaining no, the greatest advantage baako ewo criminal trial mu ne say. Se nipa miensa ne accuse wo mo, first accused, second accused, third accused. One of the accused ebetumi akwa Attorney General nkyɛn na negotiate say. Me pa ochew. Obe jame. Na emomu no betumi am enough evidence ye ring leader na gang leader in this criminal trial o de be prosecutor brana makwan sa ni nyina ne say Attorney General who say one of the accused betumi am no concrete evidence am no de prosecute the head of the crime or the criminal syndicate nipa no a head no a emransi no kwan. So betumi afa sa kwan so in plea bargain. And was say, as a practical matter, when an accused agrees to plead guilty for some reward and cooperate with the prosecution against another accused person, he immediately becomes prosecution witness. Once an accused agrees to cooperate with the prosecution, he must assist the case of the prosecution to succeed. This kind of cooperation is common in plea negotiations. For instance, under Section 71 of the Office of the Special Prosecutor Act 2017 Act 959, the willingness of the accused to cooperate with the prosecution for the arrest and prosecution of other persons involved in corruption or corruption-related offense is a factor to consider in determining the acceptability of a plea offer. The use of prosecutorial inducements, threats, promises, and coercion is an integral part of plea bargaining. The law in plea bargaining permits the Attorney General to threaten harsh punishment or promise lenient punishment or even promise absolute discharge to induce an accused person to plead guilty. The plea bargaining law accepts that. A prosecutor may adopt strategic overcharging to induce an accused to enter into a plea agreement. Strategic overcharging occurs when the prosecutor deliberately and strategically overcharges the accused person with the view that he will later drop some of the charges if the accused accepts to plead guilty to one or some of the charges. Many people have argued, a bit wrongly, that what transpired between the Attorney General and Richard Jakpa was not an attempt to initiate plea negotiation. It must be stressed that before the parties may notify the court of their intention to initiate plea negotiations, they must have engaged in some private conversations outside the court. As a practical matter, the Attorney General and the accused must have private talks to reach a tentative agreement to strike a plea deal before they officially notify the court. Plea bargaining is a consensual arrangement between the Attorney General and the accused, and each side has the right to make any offer at all. Plea bargaining can hardly be initiated without the Attorney General and the accused engaging in some informal exchanges or conversations behind closed doors. There is therefore nothing wrong with the Attorney General secretly talking with Richard Jakpa and seeking his cooperation to prosecute Dr. Casey Latofosse. Once Richard Jakpa was not represented by his lawyer or counsel at the time the leak tape was allegedly made, the Attorney General was right in communicating with him directly. Even though the Attorney General is a lawyer, his office is a creature of the Constitution, via Article 88 of the Constitution, and therefore not subject to the jurisdiction of the General Legal Counsel. The Attorney General derives his authority and power directly from the Constitution. The Attorney General and state attorneys do not require solicitor's license to practice law. Therefore, no case can be made against the Attorney General before the General Legal Counsel. Clearly, the ongoing ambulance trial is a syndicated crime, and Dr. Casey Latofosse is obviously the alleged kingpin of the crime. It is not wrong for the Attorney General to target Dr. Casey Latofosse. It is not wrong for the Attorney General to induce the corporation of the other accused persons against Dr. Kesilato Forsen. Contrary to what some commentators say, the Attorney General has no legal obligation to explain why he initially rejected Jakpe's plea offer. The steps and decisions taken by the Attorney General in this case may irritate the public, but they are neither illegal nor unprofessional. As Justice Kennedy observed in Lafleur versus Cooper 131 CT 856 2011, the reality is that criminal justice today is for the most part a system of pleas, not a system of trials. As it may be recalled, the decision of Astute in 2022 to enter into plea bargaining with the Attorney General in the Capital Bank case attracted the same level of public outcry and condemnation as in this ambulance case. The reaction of the public amply shows that many people do not understand the concept and practice of plea bargaining. Like it or not, plea bargaining is part of our law now, and we must take time and learn and understand it as we find it. Maybe we have created a monster that is hunting us through the plea bargaining, but the Attorney General has the right to use every prosecutorial endeavor to obtain assistance from the other accused persons to prosecute Dr. Kesilato Forsen, even if that means dropping all charges against the other accused persons just to jail Kesilato Forsen. Plea bargaining accepts that it has become law. Daniel Korai Counsel, Adom Legal Consult, Sunyane, Tiwei, and the in-depth explanation ya counsel diama. They said the kwasoni nyina it is part of plea bargaining. Emramu no ewum. Ni nyina wum. To asokra ka Attorney General kwa betime decide say Jakpa ena baako kwa de we can drop charges na to betime decide say we drop Jakpa charges. Ni nyina to charge Kesilato Forsen. He is still within the law. The sum of the tactics in plea bargaining and Attorney General use. The name say, and this lawyers no omon can you. Since Oma can and a political bishop into Omoya Sao. The way my hint as to how the ruling is going to be in Akopon Yaduma Ochana. If the council Daniel crying chichimo de man nyina sa na tie dia, then obi nka se pudu enhye but pudu ohia ye de ye wa ha say ye bedi nejo. So it is an interesting article and na council Daniel crying e dia betudwa ya odi abie nsemu pa ama Ghana fo ahodo a no mpese omo hunu ennyoma nkasa ehom. We kire say we need to read and learn more in matters of the law. The matters of the law and your public opinion. And your margin me say. And your margin me say. What does the law say with regards to criminal trial vis-a-vis plea bargaining? You know, and a counsel than your crime at the firm in depth